I'm David Lombardo, and this is WCNY's The Capitol Press Room. In 2024, New York voters approved adding anti-discrimination language to the state's constitution in the form of a so-called Equal Rights Amendment. But what those rights translate to in reality remains an open question. In June, the state top court shed some light on the meaning of the constitutional language as they weighed whether a mandatory retirement age for state judges ran afoul of the new protections. For more on that ruling and the implementation of the Equal Rights Amendment in New York more broadly, we're joined remotely by Rob Rosborough, author of the New York Appeals blog at nysappeals.com and a litigation partner with Whiteman, Osterman, and Hanna, where he specializes in appellate litigation. Welcome back to the show, Rob.
Thanks again for having me.
Our pleasure. Well, more than 6 decades ago, the state constitution was updated with a limitation on judges serving past the age of 70, with some exceptions. But in light of that constitutional language added in 2024 prohibiting discrimination based on a number of characteristics, including age, we had a handful of judges challenge whether that older language was still valid. On that narrow question, how did the courts and ultimately the state's top court, the Court of Appeals, find?
Well, I think you very aptly put it. It was a very narrow question before the court as to whether the Equal Rights Amendment had any impact on the mandatory retirement age for judges, which is currently set at the age of 70. And the courts looked at that very, very narrowly. They said, there's nothing in the Equal Rights Amendment that particularly targets this mandatory retirement age for repeal. And when you don't expressly repeal something through a subsequent constitutional amendment, the courts are very reluctant to hold that that provision is implicitly repealed. And the Court of Appeals, when they looked at it back in June, took that narrow view and said there's nothing here that really was intended to affect the age restriction for mandatory retirement for judges.
And what about the issue of legislative intent? If there had been something in a bill memorandum or from the legislature during the debate where they said, hey, the reason we're doing this update and not going through and cleaning up the Constitution is because, boy, that would take a lot of time. But you can assume that if we've got this new anti-discrimination language, if there is something that could be perceived as discrimination still in the Constitution, it's null and void. But we don't really want to go through with a marker and cross it all off. If something like that had happened, one, that would have been pretty newsy. But two, if it had happened, would that be something that the judges would have taken into consideration here?
So they certainly would have taken it into consideration, yes. Legislative history as described by the bill sponsors and whatever appears ultimately in the bill jacket is considered by the courts to determine what the legislature's intent in enacting the Equal Rights Amendment is. Here, you didn't have any of that. Even if you had it, if it had been sort of general, like you were describing, oh, we're looking to, affect all of these prior provisions, but we're not specifying any of them. Even that is a little too ambiguous to say that this particular provision for the mandatory retirement age of judges was intended to be repealed because it's a completely different article of the Constitution that was written and has existed in our law since, 1777 in some form or another. And so for something to particularly repeal that provision, there needed to be some intent specifically directed at that provision, the court explained. As a matter of, judicial review, they try to be as narrow as possible in their rulings so that they're not creating unintended effects, because this is a constitutional provision. It was passed by the legislature 2 successive sessions, adopted by the voters, and they don't want to change it unless there's some clear intent that that's what the voters intended.
Well, what if we weren't talking about a constitutional restriction on how long judges could serve? What if this was something that was just written into the state law? Then would the judges have had a better case for staying on the bench regardless of their age as a result of this updated anti-discrimination language in the Constitution?
I think that would have been a much closer question. Yes. Statutory provisions cannot stand if there's a constitutional provision that they come into conflict with. And this would arguably be a conflict if it was just a statutory age retirement mandate. But that's, this was in our Constitution. And so the standard is a little bit different here.
Well, another element to this story is the concurrent opinion that was written. And before we dive into that, I want to reintroduce you for listeners just joining us. I'm David Lombardo, and this is WCNY's The Capitol Press Room. And we're speaking with Rob Rosborough, author of the New York Appeals blog, which you can find at nysappeals.com. And he's also a litigation partner with Whiteman, Osterman, and Hanna. So Judge Troutman wrote a concurring opinion, which I think the big message was, hey, let's not lose sight of the fact that this Equal Rights Amendment is still a really big deal, even though I don't think the judges who are making this case here are right and should stay on the bench past the mandatory retirement age. What was it about this opinion that is kind of a bigger deal than the more narrow majority ruling?
So Judge Troutman's biggest point was that the Equal Rights Amendment is self-executing, which basically means that private parties can sue under it to remedy any form of discrimination that's prohibited by the Equal Rights Amendment in its text. So that was never settled before. And Judge Troutman's concurring opinion now basically gives another tool to civil rights litigants to pursue claims against discrimination, not only by the government, but the way that the language is written against private parties as well. And that is, a vast new tool that could be, very, very significant for civil rights litigation in New York.
Well, walk me through what it means to use that tool.
It would be one probably of a many different type of claims. So if you bring a discrimination case in New York, one new claim would be this violates my rights under the constitutional Equal Rights Amendment. And that would probably be in addition to, the executive law anti-discrimination provisions that have stood in New York's law for a long time. So this introduced not just a statutory violation, but a constitutional violation. And constitutional rights, because of how this was added to the Bill of Rights in particular, are particularly strong. And what New York has done in the Equal Rights Amendment now, with Judge Troutman's encouragement almost to use this provision, is give New Yorkers different rights than exist elsewhere. This is in our state constitution. This is more rights than you would have under the United States Constitution in the federal courts. So, federal courts, you would typically see, constitutional claims brought there, but this may actually bring anti-discrimination litigation to New York State's courts rather than in federal courts because of how strong this provision seems to now be.
Well, can you walk us through what the application of this Equal Rights Amendment might look like? Because we have this other amendment recently adopted, high profile to the state constitution, the so-called Green Amendment, and this guaranteed right to clean air, clean water, and a healthful environment. And I think there was this expectation with that from some environmentalists that they could go around striking down all sorts of laws that they felt like weren't ensuring that they had a healthful environment, or regulations wouldn't be approved without clearly passing this test. And I think they've been disappointed to a certain degree. So what are the applications of this Equal Rights Amendment moving forward? Are there clear examples that come to mind, or theoretical examples that you think will definitely be applied in the future?
So I think the notable differences here is the Green Amendment, so far as it's been interpreted by the courts, only applies to government conduct. So something that the state government does, or a municipal government, or some arm of the state. The Equal Rights Amendment goes far beyond that. It regulates not only government conduct, but also private conduct. So that's, you could bring a discrimination claim against an employer, or someone who refuses housing for you that might have been governed by, say the Fair Housing Act in the federal system, now could be brought in New York state courts to deal with the same type of discrimination under the Equal Rights Amendment. So it's different in that way. And the Green Amendment, I don't think, is yet lost. We haven't had the Court of Appeals address whether it is self-executing or applies to more conduct than just the governmental conduct yet. There are certainly cases percolating in the appellate divisions that are raising that question. So I think the Equal Rights Amendment we're now sort of at the beginning of the litigation that will define its scope and what rights it protects and how extensive and far it goes to protect New Yorkers' rights, just like we were a few years ago for the Green Amendment.
And what about this idea of what actually constitutes discrimination? Is that part of the ambiguity of this moving forward? I mean, is that what any court is going to have to decide whether something crosses that line moving forward?
It is, there's no definition in the text of the amendment itself of what discrimination is and what it isn't, and where the scope line, where that line lies. So what you'll see is in cases, courts will have to start defining the scope, and these are what the tests are that you need to prove to be able to prove discrimination on the basis of age, religion, reproductive rights, all of those types of things. And so you'll see a development in the law as these cases start to progress now that Judge Troutman has given, sort of the go-ahead to bring cases, particularly under this amendment, of how it develops going forward. So we won't really know until the courts start applying the amendment how far it's going to go, but that is definitely something you will see is the development of this case law in the next few years.
Well, when I think about the way this could be tested, I think about people who are from marginalized communities or looking to exercise rights and want, say, unfettered access to the services that they feel are owed to them. So maybe I'm looking for an abortion, but it's not easy enough in New York State as I decided, or I'm a transgender New Yorker looking for access to gender affirming care, and maybe I feel like the Medicaid coverage for those services isn't broad enough. Are those the types of cases that people might be able to change state practices citing the Equal Rights Amendment, or is there going to be kind of maybe not as much rope or latitude given to this idea that the state should go further in protecting rights as opposed to just stopping what we might constitute as discrimination now?
I think so. I think you're going to have a lot of, either civil rights groups or, private individuals who are going to try to use this amendment and see how far it will go. So you could have situations where, like the ones you described, where people bring claims and say, well, this wasn't easy enough for me, and that constitutes discrimination, and courts are going to have to tackle those tough questions. I doubt that you'll see a lot of the traditional, I'm being discriminated on the basis of my race, sex, things that we have understood in the law for a really long time under the Equal Rights Amendment, because the litigants already know, this is going to be protected because it's my race, sex, national origin, ethnicity, those types of protected classes that have been protected for a very long time. You'll see a lot more of the marginal cases to try to ferret out where the line is drawn and what rights this protects and what rights it doesn't protect. So I think you'll probably see a lot of the more, controversial type claims being brought under the Equal Rights Amendment to really test its limits.
So I think of something like New York's master plan on aging, right? This says this would be the right steps for us to take care of our seniors. And a lot of it involves spending money, and New York has not been implementing this plan. So if I'm a senior, if I'm Barb and Jim Lombardo, can I bring a lawsuit saying the state needs to implement this plan? Because if you're not, you're discriminating against me based on age, based on what you've already laid out are the right steps that you should be taking for seniors here in New York.
I think you could definitely see that. Yeah, I mean, you might be successful, you might not, and it's going to be up to the courts to define, what the Equal Rights Amendment really protects and what it doesn't, how far it will be willing to compel governmental action, but I wouldn't doubt that there will be a lot of cases brought like that will say, okay, you've got this plan for the protection of our environmental resources, but you haven't implemented any of it. We're going to bring a claim and say that I'm violating the Green Amendment, for example, and then the same thing will happen in the Equal Rights Amendment. You've got like an aging plan for New York that hasn't been implemented, and you'll get someone who says my rights are being discriminated against because of my age, because I'm not getting the plan that has been executed or intended to be executed but hasn't been acted upon.
Well, unfortunately, that's all the time we have for this conversation. We've been speaking with Rob Rosborough. He's the author of the New York Appeals blog at nysappeals.com, and he's a litigation partner with Whiteman, Osterman, and Hanna. Rob, thank you so much for making the time, and we look forward to talking to you sooner than 2 years from now.
Thanks again for having me, David. I appreciate it.
Is your business, agency, or service interested in delivering your message to more than 24 radio stations statewide carrying Capital Press Room? If so, visit capitalpressroom.org to contact our underwriting team. Join us again for Capital Press Room, a production of WCNY Connected, Syracuse.